So the Supreme Court has granted review to and will decide their first Second Amendment case since they issued their decision in New York State Rifle and Pistol Association versus Bruen. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again strike down gun control laws, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website link down below. Thank you again to SDI for sponsoring this video. As I mentioned in the intro, in this video we're going to be discussing an important Second Amendment case which has been granted Supreme Court review. That means that the Supreme Court will hear and rule on a new Second Amendment case during their very next term. The case is called U.S. v. Rahimi. In this case, the government has actually been the ones who are currently seeking Supreme Court review and were granted review by the Supreme Court because of a recent Fifth Circuit ruling that ultimately found that this federal prohibition on gun possession for people subject to domestic violence restraining orders is in fact unconstitutional under the Second Amendment and violates the recent Bruen decision. In that critical Fifth Circuit decision, that Fifth Circuit three-judge panel analyzed the federal law 18 U.S.C. section 922 G8 under the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. Bruen requires that a government's restrictions on the right to keep and bear arms must have an historical basis or analog that dates back to 1791. If it does not, then the law must be struck down as unconstitutional. The Supreme Court has now granted review to this case and will decide if they want to strike down the federal law prohibiting the possession of firearms for anyone with a domestic violence restraining order. This upcoming decision also has huge implications for other cases because we will get further clarification on how the Bruen analysis should be applied going forward in other types of two-way cases. This will help to prevent a situation where lower courts misapply the Bruen analysis like they did in a post-Heller world. After the Supreme Court issued the Heller decision, we saw a lot of lower courts like the Ninth Circuit misapply that type of analysis. Now, the facts surrounding this case are not great, and I want to state from the outset that Mr. Rahimi is not a good person. All accounts are that he is not a good person, but there are plenty of other things that Mr. Rahimi should have been convicted of, and really it's a challenge to this piece of federal law, the 922 G8, and how it's prohibiting Mr. Rahimi because he's subject to a domestic violence restraining order, how it prohibits him and other individuals from being in possession of firearms and ammunition. So between December of 2020 and January of 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, Mr. Rahimi fired multiple shots into an individual's residence. The following day, Mr. Rahimi was involved in a car accident. He exited his vehicle, shot at the other driver, and then fled the scene. He then later returned to the scene in a different vehicle and once again shot at the other drivers of that car. On January 7th, Mr. Rahimi fired multiple shots in the air after his friend's credit card was declined at a Whataburger restaurant. Officers in that Arlington Police Department area identified that Mr. Rahimi was the suspect in these multiple shootings, and they obtained a warrant to search his home. Officers executed that warrant and found multiple rifles and pistols at his location. Mr. Rahimi admitted that he was in possession of those firearms, and also later he admitted that he was subject to an agreed civil protection order, which was entered in against him on February 5th of 2020. Now, the protective order in question restrained Mr. Rahimi from harassing, stalking, or threatening his ex-girlfriend and their child, and the order also expressly prohibited Mr. Rahimi from possessing any firearms or ammunition. A federal grand jury indicted Mr. Rahimi ultimately for possessing a firearm while under a domestic violence restraining order, and that was in violation of this federal law in question, which is 18 U.S.C. section 922 G8. So it's that aspect of his conviction which is being challenged by Mr. Rahimi. Early on in his case, he brought a challenge to that conviction, and he alleged that that piece of federal law is in fact unconstitutional and violates the Second Amendment. However, ultimately he lost that argument since prior Fifth Circuit precedent found under the interest balancing approach that this piece of federal law was in fact constitutional. Well, Mr. Rahimi then appealed that decision up to the Fifth Circuit, who once again agreed and found that this piece of federal law is constitutional because of prior precedent. But then what ended up happening is we had the landmark decision by the Supreme Court, that 6-3 decision in the New York State Rifle and Pistol Association versus Bruen case. And in that decision, the Supreme Court, through Justice Thomas writing for the majority, reaffirmed that text as informed by history and tradition is the proper analysis. And if you want a text, history, and tradition shirt, we offer them here on the channel. And if you're interested, we have links down below. And ultimately what the Supreme Court did is they denied the use of interest balancing, which the Fifth Circuit had used in their precedent prior. Then after that Supreme Court decision, the Fifth Circuit panel ultimately decided to withdraw their prior opinion, which used that interest balancing approach. And then they re-reviewed Mr. Rahimi's case and ruled that under Bruen, their prior precedent was no longer valid and that this piece of federal law prohibiting firearms and ammunition possession by those subject to domestic violence restraining orders is a violation of the Second Amendment. Obviously, this decision did not sit well with the government, didn't sit well with the anti-gun side, and in fact, they decided to go up to the Supreme Court, bypass en banc panel review in the Fifth Circuit, and seek a review from the Supreme Court. And ultimately, the Supreme Court last term, at the end of their term, issued some cleanup orders, and we got news that the Supreme Court did in fact grant review of this case and that they will rule on this issue. This is significant not just for 922 G8 and the challenge to this law, but it's also important because this decision will have broader implications. The language in this decision by the Supreme Court will likely be used in all other 2A cases. And that is because this decision by the Supreme Court will have to apply the Bruen analysis against 922 G8. Also, this case and decision will center around who are the people as stated and protected in the Second Amendment's text, and that's really important. Now, recently the government filed their brief to the Supreme Court, and in it they tried to use the Bruen analysis to justify this piece of federal gun control. In their brief, the government argues that the Second Amendment does not prohibit Congress from disarming Rahimi and other individuals subject to domestic violence protective orders. Although the Second Amendment guarantees an individual right to keep and bear arms, that right is not unlimited. The government goes on to argue that the Second Amendment allows Congress to disarm persons who are not law-abiding, responsible citizens. The history of the right to keep and bear arms before, during, and after the founding era confirms that understanding. English law allowed the government to disarm individuals who were dangerous or not peaceable. Later in the brief, they go on to say that tradition further confirms that reading of the Second Amendment. American legislators have long disarmed individuals who they have found to be dangerous, irresponsible, or otherwise unfit to possess arms. The government believes that Section 922 G8 fits within that history and tradition because it disarms persons in their eyes who they believe are not law-abiding, responsible citizens. The government argues to the Supreme Court that the Fifth Circuit committed an error in their analysis by deciding that 922 G8 is unconstitutional since there was no law disarming domestic abusers at the time of the founding era. The government here argues that the Supreme Court's precedent does not require an exact historical match. Instead, they argue that the government believes that they have met their burden to justify this law by showing a broader tradition of firearms regulations which restrict potentially dangerous people from possessing firearms and other arms. So this is going to be a very interesting and important case. This is going to be a huge Second Amendment decision, and it's going to have huge ramifications going forward in all 2A cases. I have some hesitation with this case, but at this point, all we can really do is hope for the best and make enough noise in support of the 2A cause to hopefully get a pro 2A decision. So make sure you guys are staying tuned because once the Supreme Court starts their next term, pretty much within the next coming months, this case and other 2A cases right now seeking Supreme Court review will ramp up and we'll get a lot more information. So again, make sure you're sharing this news. Let people know that a new case is up for Supreme Court review. It's a critical case and it deals with a question about who are the people afforded protections under the Second Amendment. Now, of course, if we get any more information, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.